Next case is State of Ohio v. Thomas Hemingway. We have for the State of Ohio, Sean Kelleher, and for Mr. Hemingway, Edward Borkowski. Each party will have up to 15 minutes to present their arguments. The appellant may reserve up to 5 minutes for rebuttal. If you do plan to reserve time, please let me know, as I will be keeping track of the time. The arguments are being recorded, so please keep your voices up. You should not use the names of any children or victims or minors during your argument. You can refer to them by initials or general terms like the child. The judges have read your briefs and are ready to proceed when you are. And if the appellant would like to reserve time. How much?
5 minutes, Your Honor.
5 minutes. Okay. You may proceed when you are ready.
Thank you. May it please the court. My name is Edward Borkowski, and I am here representing the appellant, Thomas Hemingway. I'd like to start with the journal entry from the trial court resulting in the conviction. And I'm quoting from it. With the chaotic atmosphere created by defendant's actions, defendant must be held responsible for the results of his actions. The result being a physical attack on his daughter, resulting in a bloody nose. I'd like to talk about another atmosphere, and that is the crux of our arguments, and that is the atmosphere of the trial. I think it's, while I disagree with the trial judge's conclusion, given what happened during the trial, I think it's probably not surprising. And what I'm referring to is generally the second assignment of error, which is the ineffective assistance. I guess I'll start with this. Everyone has bad days. Everyone makes mistakes. Everyone forgets things. That's natural. But I think that when you read the transcript here, what you have is a trial that was rife with instances where Mr. Hemingway's counsel should have intervened, should have stopped certain testimony from coming out, and further elicited certain testimony herself by the way that she cross-examined some of the witnesses. I know that there's a difference between a jury trial and a bench trial, but the principle still applies that you can't unring a bell, or one that I like more, you can't throw a skunk into a jury box and instruct the jurors not to smell it. In this case, the judge heard numerous instances of not just what did or didn't occur on that particular day, but how Mr. Hemingway drank too much, or he got angry and he was always fighting with his wife. These things clearly do not apply, not relevant, should have been excluded under Rule 404B. And what it did was, rather than having the trial judge focus simply on what did or didn't happen, what do I believe based on the testimony? Instead, there's this whole backstory about the atmosphere that this gentleman creates in the home through his behavior in the past, and why his wife and his daughter were afraid of him, of what he might do because of what he did in the past. All of that should have been excluded, and counsel really dropped the ball when it comes to objecting, intervening in some way. The state in this case didn't file a notice of its intent to present 404B evidence, from what I can tell from the record. So all of that should have been excluded. It didn't fall under any of the exceptions. And while I know that this court probably tends to look at a bench trial and say, well, the judge is presumed to consider the appropriate evidence, but judges are human, just as we all are. And with this barrage of testimony related to other acts, unrelated acts, prior bad acts, there was no way for Mr. Hemingway to get anything close to a fair trial, because not only were his behaviors, whatever they may have been, under scrutiny, but also any previous actions that were alleged to have occurred. So I think that in general, counsel was deficient, and as I've outlined in the brief on pages 9 and 10, there were many specific instances where it would have been very easy for counsel to say, Your Honor, objection, that falls outside of what the rules of evidence allow, and I would ask the court to strike that. I'd like to move on to the manifest weight portion, but does the panel have any questions as to ineffective assistance so far? I think the heart of the case when it comes to the manifest weight argument is the testimony of the child. Excuse me one moment. The testimony of the child. In reviewing the record and the transcript, her testimony seems to me, minimize the actions of her mother. Specifically, the mother testified that she hit Mr. Hemingway, testified that she hit him, that she struck him, while the child testified that I think she maybe tapped him or something like that. So she minimized her mother's actions while amplifying what Mr. Hemingway supposedly did. Compare how the mother testified as to the moment when this assault, or rather domestic violence instance, occurred. Mother testified that while Mr. Hemingway was trying to get the phone from his daughter, they fell to the floor. That was the word she used, fell, which I think anyone, lawyer or non-lawyer alike, that conjures up the notion of accident. I fell. It wasn't on purpose. It wasn't knowingly done. On cross-examination, we mentioned this in the brief, the prosecution first added the word tackle in cross-examining the mother, whereas that is not how she testified. So compare that to how the daughter characterized Mr. Hemingway's actions, that she mentioned tackle, she mentioned smushing her face, whereas mother said nothing of the sort. And I think it's important to note that mother specifically said that no one was trying to hurt the child, neither one of them. They were trying to get the phone. I think that when this court stands in its role as the 13th juror, or in this case, I suppose the second judge, and considers the manifest weight, did the state present enough evidence with enough weight? Was it compelling enough to say beyond a reasonable doubt that Mr. Hemingway committed the acts that he was charged with? I would submit that it in fact did not. I think the sequence of events is important. Now, there were variations in the testimony as to that sequence of events, but I think that the overall narrative that this court is going to be left with is that there was some kind of argument, there was a back and forth about this phone, and then the family sat at the table. If we're to believe the child, at that point, she was bleeding so heavily from her face, specifically her nose, that she needed to get up and go get a towel to sop up the blood. But neither Mr. Hemingway nor his wife noticed this fact. Neither one of them saw blood on the child's face. So these things don't make sense. And I know that juries take a common sense approach, and I think that judges do the same. Does this make sense? And I know that there is, this court will be deferential in its review, certainly. But it still stands back, looks at the evidence as a whole, and decides, has the state met its burden? And I would ask the court to find that it did not, in fact, meet its burden, and reverse this matter and remand it to the trial court. Judges, I apologize. I thought I started my timer, but I didn't, so I'm not sure how much time I have left.
Mr. Borkowski, you have 6 minutes and 37 seconds.
Okay.
Counsel, could I ask you a question?
Yes.
Excuse me. I don't think you mentioned the bloody towel. The state did mention not only that there was blood on the shirt that you were hypothesizing could have been ketchup, but also the state mentioned a bloody towel.
The state did mention a bloody towel. I don't believe that either of the responding officers, I'm trying to find the place in the transcript. I don't believe either of the responding officers mentioned a towel. They mentioned a sweatshirt with what appeared to be blood on it. When questioned further, neither of them, they said, well, it was the impression that we got that it was blood. Neither could say with certainty because it was never tested, it was never examined. The towel, I believe, was mentioned by the child. So without any sort of corroboration, I think that we can take that for what it's worth. I hope that answers your question.
Thank you.
Any other questions? Mr. Borkowski, you have 5 minutes and 20 seconds. Would you like to reserve your time?
I would, Your Honor. Thank you.
Thank you. Mr. Keller, you may proceed when you're ready. You're on mute, though. Okay.
Thank you, Your Honor. May it please the court, Sean Keller for the city of North Ridgeville. I'll address the arguments in the order that they were presented, Your Honor. I do know that the court has read the briefs, and I do know that the transcript was short. It was a short trial, but as to the manifest weight, Your Honor, as this court is aware, the manifest weight, in a manifest weight review, the court would have to find that the trier of fact clearly lost its way. Additionally, the credibility of the witnesses and the weight given to the evidence is primarily for the trier of fact to determine. Lastly, the trier of fact is free to believe or disbelieve in whole or in part the evidence that comes before it. And because he, she, or the jury is in the best position to view the testimony, the live testimony of the witnesses, their judgment is not to be easily dismissed, Your Honor. So I guess I would say, can it fairly be alleged under a manifest weight argument that the court lost its way when the police were called to the house? There was a home with overturned and broken furniture. There was a 16-year-old girl with puffy eyes and a swollen nose with blood on her shirt and a bloody cloth nearby. That is in the record, Your Honor. They find a broken phone. Can it be said that the court lost its way where there were two witnesses, the mother and the daughter, who described nearly exactly the same events, demonstrating that the husband/father, the appellant, should be arrested for domestic violence. And then they are both noted to be highly emotional and then demonstrably relieved when the defendant is arrested. Can it be fairly alleged that the court lost its way when the 16-year-old girl, the victim, then gave absolutely unshakable testimony to the facts at trial that her father, of whom she was afraid, tackled her to the ground, bent her arm back, used the word smushed her face into the floor, and that it hurt. And then pushed her, when they became disentangled and they stood up, then pushed her back down to the floor, smashed her phone, flipped a table at her while calling her names such as being a whore. I think, Your Honor, that there's more than, Your Honors, that there is more than enough in the record to overcome a manifest weight challenge. If there are no questions, I'll move on to ineffective assistance of counsel. The ineffective assistance of counsel, Your Honor, as this court is aware, and I wrote a very short brief because I know that you all know much more about these issues than I do. I cited the seminal cases, but there's a strong presumption of adequacy for lawyers to do so would be unfair, to do otherwise would be unfair, and that the actions of counsel would be sound trial tactics. Further, the appellant has to show that without the counsel's errors, there exists a reasonable probability that the result of the trial would be different. So this puts me in everyone like me that has to fend off a ineffective assistance of counsel argument. This puts me in a strange position of validating defense counsel's arguments that I earlier attempted to defeat. You know, consider, your honors, that it was 10 months between the charging of the case and that of trial, and that there were, on the record, there were at least 9 pre-trials. There were 2 lawyers. The appellant substituted his first lawyer in for his second, of whom this ineffective assistance charge is leveled. And that last counsel had 7 months to prepare. Often, your honors, defense counsel are asked to do a lot with a little, and that was the case here. In the face of overwhelming evidence, including devastating testimony from the defendant's 16-year-old daughter, the appellant's counsel was able to create a defense. She developed themes, and some of those themes were that there was a messy divorce brewing, sort of what I called at some point, I think, in the sentencing, what we often think of as pre-divorce positioning. You know, let's get our spouse arrested. That'll give me a hand up in child custody, maybe. But that was a theme. And the daughter and the mother were conspiring to gain an advantage in that divorce. And to that end, the defense counsel developed that the officer didn't separate the witnesses when he initially interviewed them, thus alleging or inspiring collusion. The fact that the mother and the daughter shared a special bond, and the mother might be afraid of being deported, was an attempt at helping that theme. There was a allegation that the blood on the sweatshirt was in fact not blood. That was called into question, that it might actually be salsa because it wasn't tested. The counsel was working, Your Honor, with what she had. She developed that the mother was in fact the initial aggressor. She developed with the police officers that
Counsel,
Yes.
if you'll refrain from saying her name and just use initials for the mother as well.
Oh, yes, Your Honor. Thank you, Your Honor. That the mother was the initial aggressor that was developed. That the police feel that they have to make an arrest was developed. That the defendant was merely a concerned parent because he was worried that night that the victim was sending nude photos to her newly discovered boyfriend. There was absolutely, by the way, no evidence of that ever raised. There was a theme that the mom is dishonest and can't be trusted because at one point after this incident, she had lied to protect her daughter, who had been driving the car alone with just a learner's permit when she was in an accident that was not her fault. That the mother was further dishonest because she had knowledge of her daughter's boyfriend and didn't share that with her husband. There was the theme that the counsel developed, that the victim was not really afraid of her dad because he was possibly her first call after that aforementioned car accident. Counsel was engaged, and she successfully objected on at least 2 occasions. And in her closing argument further, Your Honor, in the trial transcript, I think it starts at page 99, and I invite you to go ahead and look at that if you want, but she kind of wrapped up these themes. She does a fair job of reasoning that it was not her client's intention to cause physical harm to his daughter when they landed on the floor. Rather, he was just trying to get the phone, and the actions didn't meet the knowingly standard required for the M1 crime of domestic violence for which he was charged. Consider also, Your Honor, that her arguments caused the judge to take the issue under advisement, and he didn't issue a decision for more than a month. Plain truth is, Your Honors, that defense counsel can't always, unlike, you know, the fable Rumpelstiltskin, they can't always spin straw into gold. And in this instance, there were no errors committed by the defense counsel, if they were cured, would have changed the outcome of the trial in the face of the testimony of the victim and the physical evidence. So it's for those reasons, Your Honor, and the others that were set forth in our brief, that I ask that this appeal be denied.
Thank you very much, counsel. Mr. Borkowski, you'll have your full 5 minutes for rebuttal.
Thank you, Your Honor. I think that I agree with Mr. Kelleher as to what the standard is as it relates to this court's review. I think in this case, the trial court did lose its way. And I think the reason for that was the abundance of testimony and evidence that should never have come in. One thing I do want to point out, I don't believe I mentioned it before, is that this was not Mr. Hemingway is the one who called the police. This was not some strategy by mother to have him taken away in handcuffs. He's the one who brought the police to the house because of the fact that she struck him. The reason why the mother and daughter had the same, well, more or less the same recollection as to what occurred that night was because they stood next to each other as mom gave her version to the police. The officers didn't separate the two to try to find out, ask mom what happened, ask daughter what happened. They all talked together, and so the narrative became one. As to ineffective assistance, I realize it's an uphill burden, and none of us wants to sit here and claim that another attorney didn't do his or her job. It's not pleasant. But in this case, I have a client who was deprived of his right to have a fair trial. And I think that was largely, if not entirely, because his counsel fell short. It's unfortunate. I know that we're limited here to the record, and I know that I attached some things to the brief that I think this court struck. But Mr. Kelleher says the counsel had 7 months to prepare. Well, that doesn't mean the counsel adequately prepared. It doesn't mean the counsel spent that 7 months doing everything the counsel should have done. I won't say any more because we're getting outside of the bounds of the appellate proceedings. But there were certainly a lot of things that could or should have been brought up that were not. I believe I've covered what I wanted to cover, Your Honors. So unless there are other questions, I would rest at this time.
Thank you. Any questions? Okay, well, thank you both very much for your presentations. The court will take the matter under advisement and issue an opinion in due course. The clerk of courts will mail a copy of the decision to you on the day it is released, and it will also be posted on the Ohio Supreme Court website. Thank you both.
Thank you.